I believe we have the opportunity to turn now to ABC 24's Kevin McNamara, who joins us now with a guest to kind of help break down some of what this means. Kevin?
Yeah, that's right. Thank you, Ruben. I'm joined by Alex Wharton of the Wharton Law Group. Alex, thank you for being here. I guess, what's your first reaction, first question?
Well, I wish I could say I was a soothsayer and predicted it, but I did not. Somewhat surprised, especially considering some of the lesser included offenses that the jury was instructed that they could consider. But as we heard, this was a very short trial. 3 days of actual proof and some proof from the defense, which is not that common. And then we get to a verdict in less than 24 hours worth of deliberation. So somewhat surprised, but the juries know what they want to do pretty quickly. And typically, kind of the rule of thumb that we follow as defense lawyers is the longer that the jury deliberates, the better it is for your client. They're discussing certain things, but this was a very limited amount of information, very limited jury verdict form that they had to consider essentially 3 charges, all wrapped around the same thing. So it wasn't a lot of complexity there. It was really about, did they believe the state's main witness or did they not believe it? And that's what it came down to.
Yeah, I mean, it seems like in a case like this, there's not that much physical evidence to deal with at all, right?
That's correct.
The state was never alleging that Govan was the man who pulled the trigger.
Right.
So his argument is, why are you believing what?
Correct. The entire case is credibility of what he says, Cornelius says, as opposed to, well, we don't have to say anything as the defense, but do you believe the state's main witness? A young man who has a lot to gain or lose based upon his testimony, and not just this trial, but prior trials, who's facing the same charges, who was actually admitted to be the gunman, the one with the most powerful weapon. And so when you deal with that, and then a lack of true evidence, no concrete text messages to show, yes, we got him, or this is the plan, or we are here, nothing, no content. The only thing that I understand that state to have produced to the jury for them to consider were, you've got multiple phone calls. And for Mr. Govan to be the admitted dealer of the state's main witness of supplying pills and all those things, that would not be a surprise if you've got multiple contacts, they live in the same neighborhood. You can't just go off of, well, I called this person a ton of times to prove a conspiracy case. That's a little bit of a stretch.
Yeah, so what happens now then?
Well, I think, as the state somewhat alluded to in their closing argument yesterday, and somewhat in the way of the proof through one of the law enforcement witnesses, are there additional parties who could be complicit in the conspiracy? I don't know if that's the case. We heard Mr. Mims' name mentioned a lot, but he's now deceased. So obviously nothing can come of that. It just, I think they need to take a step back and probably regroup and see if the investigation needs to go anywhere or if it just rests there. They do have at least 2 of the individuals, the most complicit, the actual shooters, accepting responsibility in one case and being found guilty in the other case.
Yes, so do you think this makes it more or less likely that they're going to be able to go after, higher up parties?
Less likely. I mean, you would be putting the state's main witness on now for a 3rd or 4th or 5th trial. And every single time that he goes and gets on the stand, the hope as a defense attorney is his testimony changing? And bit by bit, piece by piece, it's just like he becomes a weathered person at that point. I mean, that's a taxing thing to be on a stand, multiple trials for multiple hours at a time, and have to remember and be consistent with everything.
Yeah, I mean, to your point, it was a pretty quick trial. We were to come to this conclusion within just 3 or 4 days.
Right.
Seems like the jury knew kind of what they were going to come to.
Well, I don't know if that's the case that they knew. I mean, well, obviously, from a human perspective,
they decided
told not
quickly.
Exactly. I mean, it was one of those things that they probably had to go back into the jury deliberation room and say, do we believe what he said, the state's main witness? Forget what the girlfriend said for the most part. Law enforcement's testimony wasn't really helpful whatsoever. The autopsy, it was what it was. But does this young man's testimony line up? And do we have enough? And what a lot of people fail to remember is that it's not just beyond a reasonable doubt. It is beyond a reasonable doubt for a criminal case. But in our jury instructions, as Judge Johnson Mitchell read to the jury yesterday, it requires a moral certainty. And that level of certainty that you would exercise in your most important affairs, where to put a child, a sick parent, where to move, things higher than that, quite frankly. What to do about a parent who's suffering with a deliberate, just a horrible illness or sickness. Those are the levels of certainty that you have to have when convicting a person, because truthfully, you obviously taking the person's freedom away. And the jury knows the stakes, even though they don't know the potential consequences and aren't told about the punishment options. They know the consequences. You're dealing with the most serious offense of first-degree murder, and when you do that, the state better come correct with enough evidence to let you rise above that level of certainty from a moral perspective that you need to have to convict.
Yeah, it's a great point. What do you think this means for Memphis then? You know, Young Dolph is such a beloved figure here. You've got someone on trial being the alleged mastermind. Does it feel that justice is served? It's hard to say.
You know, I don't know. His iconic status and his legendary status, not just in the music industry, but what he's created with his label record, I think that continues to go on. I think we need closure. Right or wrong, the verdict is what the verdict was. We can disagree with it, we can agree with it, but we have to respect it. And we have to look forward, quite frankly, as to what we can do as a city, not only to honor the legacy of Mr. Thornton, Young Dolph, but bigger than that. You know, how do we cultivate additional artists, young artists, let them do it the right way? We've got young artists coming up now who we can support, continue to encourage them to preach in their own method the right things, you know, that you can make it out of the worst of circumstances, but you don't have to stay there. You know, give them something higher to look forward to. So I think that's the message for the city. We've got great talent here. What we do to encourage that and foster that is what's most important, and that will be the ultimate honor of Young Dolph's legacy.
Yeah, and then from the state side, this is now the second kind of high-profile case here in recent months in which they failed to secure a conviction. It feels like, is that say anything about kind of the prosecutorial ability?
I don't think so. I mean, sometimes you have the proof and sometimes you don't. Defense attorneys, we're accustomed to taking a lot of punches, I would say. You know, any defense attorney who says that they have a perfect record is probably pleading their clients out every single time that they get. So you preserve a perfect record.
Right.
But those who go to trial, you withstand some punches, and so we have to get used to it. But the state typically is going to have a 90+% conviction rate. So that's a hard task to continue to do, especially in a conspiracy case where you don't have anyone else to testify to support the main witness of the state of Tennessee. So I think they regroup. They'll continue to prosecute the lesser profile cases, but those that are just important or as important as this case. So their work goes on. I don't have any concern or questions about the ability of the prosecutor to do their job from here.
Yeah, how rare was this sort of case then, generally speaking, where you don't have, again, there's no allegation that the man on trial is the one who pulled the trigger?
Yeah, I mean, that is a very rare case because there's nothing other than that main witness. The other co-conspirator, straight drop, I can't remember his actual name, but he was convicted already. He's not testifying to help the state whatsoever, so it rests with this young man's credibility. But conspiracy cases, by and large, on the state side are very rare. And if they have those, typically they want to have more than just the word of the individual. They want to have things that corroborate. They try to do that with the cell data, but that only gets you so far. That just shows that calls were made. It doesn't talk about the content of the calls or the discussion. There's no recording. There's no Facebook messages or exchanges. So they want to have something that supports that, even if you don't have the smoking gun as to prove, hey, that conversation took place. You have enough circumstantial evidence to convince the jury, hey, look, this is what I mean when we say beyond a reasonable doubt into a moral certainty.
Yeah, so is this kind of the closing of the book then, in your eyes?
I would estimate so, unless something drastically unknown or unforeseen happens. I mean, we're talking about an incident that took place now almost 4 years ago, in November. You would think and hope that law enforcement has turned every corner and stone that they could to identify those people who were involved in it. Never say never, but I would be highly surprised if anything else comes of the prosecution.
All right. Well, Alex Wharton, thank you for being here.
So
We appreciate it. There's a lot of great info there, really helpful perspective. Ruben, we're going to send it over back to you. I know we have a lot more to get to here.